Former South African Airways chairperson Dudu Myeni has been reprimanded at the state capture inquiry for revealing the name of a witness who wanted to remain anonymous. Deputy Chief Justice Raymond Zondo adjourned the commission for lunch to consider this action. Let's see what actually transpired.
For the first time, chairperson, I read Mr. X's full document. And your office, chairperson, has the SIU investigation against Mr. X. But, chairperson, I'm going to ask you stoically, Chair.
Would you like us to take a lunch adjournment and you...
No, Chair.
Oh, okay.
I'm saying stoically, Chair. This is a distraction of a family member. There is no truth in hiding his identity.
Ms. Myeni.
This is an honest man.
Ms. Myeni.
That I've known for over 25 years.
Ms. Myeni, if I've made
are you talking?
an order, yes.
I'm sorry, I beg your pardon.
Yes.
Or did you not hear me?
Ms. Myeni, I'm controlling the proceedings in the commission. I give you an opportunity to say something, and I give everybody an opportunity to say something. At this stage, I want to say if there is an order that I have made, it needs to be respected.
Evidence leader Kate Hofmeyer accused Myeni of violating the Commission's Act by naming the witnesses. The Deputy Chief Justice ordered the Myeni's legal team to make a submission about her breach by 10 a.m. on Monday.
We submit that conduct is a willful obstruction of the Commission in the performance of its functions. It reveals a disrespect for this Commission and its processes, and it will send a chill over these proceedings, because it is liable to deter future whistleblower witnesses from coming forward. We submit that this is an extremely serious matter, and we submit that you should direct the Secretary of the Commission to lay a charge against Ms. Myeni for breaching Section 5 of the Commission's Act, so that justice can take its course. We further submit that any explanation of Ms. Myeni's conduct that may be proffered by her, or any indications that may in due course of regret that come from her, are matters that are appropriately to be reserved for her criminal trial on this charge, should the NPA decide to prosecute. They are not. Any offers of explanation or contrition are not and could never be grounds for not directing that the charge be laid. Chair, it is our submission that the proper functioning of this Commission requires matters like this to be dealt with resolutely and swiftly, so that there can be no doubt that people who knowingly undermine this Commission will be brought to book.
In her defense, Myeni claims she wasn't aware she'd named the witness.
Honestly, I am feeling so bad about this whole thing, because I don't mean to disrespect anyone. And especially, I don't mean to disrespect the Commission or the chairperson. I am feeling very bad. But Ms. Hofmeyer, if I've mentioned him again, it will be out of, first maybe out of, I don't know, I did not hear myself whether I said his name or not. One, it was disbelief. Two, it was an emotion that came with it, and feeling betrayed. I apologize, but if I've said it again, it's really something that I've not. I think my mind is not into it. I apologize.
Ms. Myeni,
I hear you questioning me, so that's why I'm saying I don't know whether I've said it again.
Okay, you'll refer to him as Mr. X.
Right now, former SAA chairperson there, Dudu Myeni, giving testimony today at the State Capture Commission, which really has been marked by her refusal to answer questions, claims that she has been unfairly vilified, and of course revealing the name of a witness. And that chairperson, Raymond Zondo, had to order must be withheld. Now, is she undermining the commission, and what should be done if someone is seen to be undermining the commission? Wits University law professor and advocate James Grant joins us now to talk to this issue. Advocate James Grant, good evening, and thank you for joining us on the Newsfeed Late Night.
Good evening.
I want us to start right there. Let's first talk about this issue of revealing the identity of an anonymous witness. According to Section 5 of the Commissions Act, anyone who willfully interrupts the work of the Commission can be charged, and that person can be fined or even jailed. Would you say Ms. Myeni needs to face a criminal charge for what she did?
I think on the face of what we saw today, it certainly deserves to be investigated. She mentioned it on my count 4 times, and on both sides of being reminded by Judge Zondo that the individual's name was indeed protected. And so there certainly seems to be a case on the face of it for an investigation at the very least.
Now, her defense says, look, I was probably emotional, it's a human error. Would that work as a defense?
It doesn't work very well in ordinary criminal offences. The last time it worked was in about 2002 or so. It hasn't worked for a very long time. It's unlikely to work here.
Now, then let's talk about what others are revealing coming out of this particular process, that the process itself of hiding the identity of the witness has been flawed in a sense, because within the state capture itself, it has already been revealed that Mr. X is a sole director of Company X involved in specific transactions. And it doesn't take rocket science for you to go to the CIPC and find out who that person is.
Yes, one can only say it's unfortunate because it may well have the effect of chilling the intentions of other prospective witnesses who were going to come forward. One can only hope that they're able to somehow tighten this up.
Now, would you characterize this as a witness that is deliberately undermining the work of the commission, and particularly also looking at the many instances in which, and we'll play them in just a moment, where she's asked questions and she just refuses to answer?
Well, I think that her reliance on the right to silence, or her right against self-incrimination, is just straightforwardly wrong in law. And I can say that because our Constitutional Court, a very long time ago in 1995, decided that that right, in fact, is a right which is exclusive to criminal proceedings. And the protection that one gets is that if in a criminal proceeding something that you said in some other inquiry or commission is tendered into evidence, that evidence becomes inadmissible in the criminal trial. You are not entitled by virtue of this right to refuse to give answers in a tribunal or commission.
But would then not the amendments that were done to the Commission's terms of reference now come into play, where it was said in those amendments that now the NPA can act and arrest people based on the testimony that comes out of the Zondo Commission?
The amendments, the regulations and the fiddling, I'd like to call it, to the regulations were most regrettable because all they really did was lead to confusion. The law relating to privilege and the law relating to the right to silence is governed ultimately by that case that I referred to, the Constitutional Court decision in Ferreira versus Levin. And nothing that either President Zuma or President Ramaphosa attempted to do by fiddling with the regulations could change that. And so ultimately, unfortunately, at best, all that did was lead to confusion.
So are you saying that according to this case law and precedents that has been said with regards to the work of the commission, if one testifies at the commission to say, well, such an amount of money was transferred from my account to this account, or that money came into my account, I then withdrew it and I put it in a bag and I gave it to this one, that kind of testimony could in essence not be used by the NPA to follow their criminal investigations?
The Constitutional Court was careful to draw a distinction between what it called direct evidence, which is expressly what the person says, such as, I shot John, as opposed to what it called indirect evidence, which is that if a person says, well, I thereafter took the gun and threw it in a river somewhere, the Constitutional Court took the position that what the person expressly said, such as, I shot John, cannot be admitted into evidence in a subsequent criminal trial. However, it did say that the indirect evidence, such as that you took the gun, that the gun was thrown into a river, if the police were to follow up and to find the gun, that gun could be admitted into evidence as indirect evidence. And that was the distinction that the Constitutional Court drew, and that's what is the governing position in our law right now.